All right. Hi, everyone. This is Kurt Barone,
And Brad Pinsky.
and we're here for another edition of File or Roundup for September 22nd of 2025. Brad, go ahead.
I would just like to know, I think we're coming up on 3 years of doing this, or am
Is it?
I just totally wrong?
Yeah, I think it is. I think it
I,
is.
I think we got to look back, but I think this is coming up on the anniversary or is the anniversary. So it seems
Yeah.
like it was yesterday, but to everybody who's subscribing and liking, we really appreciate them, obviously. And I know you say it at the end, but if you're just watching this, right,
Yeah.
subscribe.
Yeah, please subscribe, click like, share. All of that helps our algorithm and helps us to get noticed, shows up in people's feeds, and that in turn helps us to keep doing this. So,
All right, let's start. Boy, sometimes we get to these stories and I'm like, I should be really careful what I say so I don't become a victim of the reporting, right? But we're going to start with the FDNY, where we have an assistant commissioner who resigned following racist concerns. So here's what happens. There was a incident, let's call it a team building exercise where it's a little confusing whether the commissioner was there or overseeing it or
yeah,
created it.
well, I think we got to take a step back too and say that New York has, and we did this in Providence as well at one point, but in order to recruit a diverse workforce, they get into the high schools and have programs that sort of steer kids even through their high school classes into public safety, police, fire, EMS. So FDNY apparently has participated in one of those things, and this incident happened at apparently a high school where this was, I guess, the central focus. Fire and life safety was the central focus of the high school.
Right. Yeah, and they call this the Youth Workforce Development Division, right, of the FDNY.
Of the
And
effort, right,
so they're doing this, and we should say that a majority of the students there are Black or minority students.
right.
And before we say why this was deemed racist, I want everyone to listen and say, would you have caught it? Right?
Mhm,
Because I'm going to be honest, it
mhm.
was only after I read why it was a problem that I was like, oh, right. So they run this team building exercise where they basically tie, I think, their hands of students behind their back. They put petroleum jelly on their faces, which becomes sticky, and they are asked to collect cotton balls using only their heads, right? Putting, I guess, the sticky stuff on the cotton ball and it would cover their heads. I,
Mhm.
I didn't understand where this was going. Maybe
Yeah.
I'm insensitive, but I don't think so. And what blew up out of this is saying, wait a minute, you're having Black youth pick cotton, right? And now you hear it and you're like, oh, wait, that's bad. But here's the thing. I have a hard time believing that even the most racist of people, and I'm not saying this commissioner was, but even
Mhm.
the most racist of people would be that bold as to lead that exercise with that knowledge or intent. It's certain things like, look, I'm Jewish, other people are something, right? And so people will say something and they don't realize it's offensive. And now
Mhm.
that may be ignorant, right? But it's not intentionally offensive when somebody says something to me about Judaism, whatever. And so, I always chalk it up to, okay, you didn't know, and I can help educate so you don't do it again, but I wouldn't necessarily fire you. Here, this individual is now trying to resign or is resigning, right? In question about pensions and
Yeah.
everything. But, I feel badly for the individual. I feel badly for the kids. I feel
Yeah.
badly for everybody involved because my own personal opinion is I can't believe anyone would intentionally and knowingly do an activity that was like that. And maybe this is, it's the DEI issue. Maybe it's not. But that's what happened.
Yeah, and from my perspective, I'm wondering how many steps away from the actual exercise was the commissioner? Okay,
Right.
was she overseeing the program and did she know that it was being done? Was she actually the one that created the exercise or signed off on it? So, how far away, how many steps away from it was she? And, I think I would characterize it not so much racist, but racially insensitive. I think that's the proper term. And, certainly someone who's a commissioner in FDNY, you would think with everything that FDNY has gone through over the last 20 years or so, your antenna would be up, and you'd be sort of looking for these types of problems. Maybe in a different fire department that hasn't been through some of the challenges they've been through, this type of thing. But it certainly is, I mean, I've had to come up with different exercises, and I had never heard of this particular exercise. There's a number of other ones, but it's just another thing that I guess you got to think about when you're putting these things together. And you said I was in a class, and the teacher, the instructor, made a reference to it was an Italian person's last name, Stromboloni or whatever. He says, sounds like a type of pasta. I could have taken offense to that. You know what I'm saying? But
Right.
really,
Right.
that,
That's the question.
but
Is it intentionally,
right,
there's a line, right? Which is somewhere between hateful and
right,
ignorant and unintentional.
right.
I,
Right. And well, that's why you do an investigation, also. So, but apparently there were some other things that came up. Now, whether they
yes.
were the result of somebody who probably wasn't a good fit for the program complaining, or whether it was someone who has a legitimate gripe. We don't know, but there was some other issues that sort of got in the way.
They claim
And
she made a racially charged comment of,
right,
people not being qualified based on their
right,
race, right? So if you put the two together, you might then say, okay, well, anyone
right,
who would make that comment, if it's
right,
true, right, and then lead that exercise, maybe it was intentional. Who knows?
right. But if you make a comment that you're not qualified to someone who is not qualified, you're not
Right,
saying it to everybody. They're
right,
saying, no, you or you three are not qualified, and we're going to dismiss you from the program. You're not meeting the minimum requirements. But again, we don't know the context. We don't know anything. All we know is the allegations, which can be kind of slanderous. And certainly I don't mean to slander the assistant commissioner or anyone else here. We don't know, but I think as someone who from time to time, I haven't had to do it in a while, but have to put together these leadership exercises, team building exercises. Certainly something that you want to think about, and certainly not create a bigger problem than the one you're trying to fix.
right.
So,
I just, yeah. So it is hard to be, it's easy to be insensitive. It's easy to overlook things. Whether you should be terminated, that's up to the FDNY, I guess. Okay, boy, if anybody has not watched the hearings, and especially the clip you took of it, okay, we're under the lawsuit against the Fire Apparatus Manufacturers Association by the Department of Justice,
mhm,
and against Pierce and the Rev Group,
mhm.
Pierce being separate from the Rev Group. But I'm going to assume people have watched it. I'm going to highlight some points. If you don't know what I'm talking about, go watch it. But I want to first come to the defense of the only for a very short time of the apparatus manufacturers of Pierce and the Rev Group. I forget all the departments of the Rev Group, right? But think of the big manufacturers out there. You got Sutphin, Seagrave, KME, right? HME, Rosenbauer. You got a ton of them, plus Pierce, right? But there's a ton of these manufacturers, and there's more. So the only thing I note where I'll give the manufacturers some credit is, I guess the lawsuit alleges DOJ, and these were Senate hearings, but the DOJ lawsuit alleges that, or investigation is alleging that Rev plus Pierce is 80% of the vehicles. I could see that, right? But again, Sutphin, Pierce, or Sutphin, KME, HME, there's a million others,
Well, I'm
Rosenbauer.
not sure how many of those are owned by Rev Group. Rev Groups owns a number of different manufacturers, so I'm
Right.
I'm not sure which ones of the ones you mentioned are in Rev Group or are not in Rev Group.
Yeah, and I'm just going to do a really quick for the benefit, of our of our show, the Rev Group, as they list it. I guess I'd have to see who's here. Let's see their brands, right? E1 for our KME, Smeal, Spartan. So yeah, that's a lot of them. I don't know if
Yeah,
that's everyone. You're right. You're missing
yeah,
Sutphin and some others, but that's a pretty significant size group. In any event, that's the only defense I'm going to give. But
sure.
here's what this, I think it was a senator or something, or a congressman, I'm not sure.
Senator Hawley.
Senator, okay, so he was awesome, by the way,
Yeah.
and prepared. And some of his 6, 7 highlights. He points out one because the manufacturer representative from Pierce who was there said, oh, it's inflation and input costs, right? Input costs meaning inflation. He said, wait a minute, your increases are 7 times higher than inflation. So he nails him on that, but it wasn't the big gotcha. That's coming up. He said, your profits have doubled despite alleging that it's inflation what causes the issue, right? So profit doesn't double if inflation is increasing your costs. He said the gross profit margin is now 12 to 14%, but pre-COVID was 4%. So, I mean, 3 to 4 times profits. He said their revenue growth projection used backlogs. Now, this is a big thing. They're talking about backlogs. And the guy's saying, look, it takes time to manufacture a truck, whatever. And he pulls out statements that were made from FAMA and from Pierce, from the CEO by their CFO from Pierce, saying that they're using backlog as a way to increase pricing, quote, which will enhance our margin. So they're using these 3-4 year backlogs. And I thought, well, wait a minute, how is it their fault? What they're saying, what he said is, Senator said is, they're laying off people intentionally to create backlogs, and then quote, which will enhance our margins. He said they have double-digit price increases in their backlog, and this will continue. Think about that, right? So Pierce says that CFO or whoever it was, CFO or CEO, they both made comments that were quoted by the senator, says we'll have double-digit price increases in our backlog, and this will continue. We're still going to see double-digit price here. We just saw a doubling, and now we're going to go up 10, 15% a year. Insane. And they said the 3-year backlog will continue to see the, quote, to see the benefit of pricing. Right? So they're counting, allegedly, right? The Senate was saying, on their backlog increasing the price. Then they said, well, what's the relationship with FAMA? And he said, aren't you conspiring? Because they're going after antitrust. So this guy, the senator, was trying to tee up the charges and the proof. And he says, FAMA, the Fire Apparatus Manufacturers Association, he alleges that Pierce and the Rev Group fund it, which apparently they do. The guy from Pierce is very around the edges, like, oh, I don't share this. I've never gone. We don't share information. Because here's the point. The senator was trying to say, and I think they're going to prove, that FAMA is a way for Rev and Pierce to conspire on fixing their pricing and their delivery times, et cetera. And he pretty much shut that Pierce guy down, who was evasive, in my opinion, was very evasive. And then he pulls out FAMA's purposes, by their own definitions, to collect and distribute data on pricing. Yeah. For what purpose other than to conspire, presumably, is where he was going. So it's 7 minutes. Everyone should watch it. It is damning.
Yeah, and I think Senator Hawley makes a statement toward the end, and you can't really see who he's pointing to, but he's pointing to a group of firefighters and chiefs, and I think the IAFF was there as well, saying, you need to take care of these people, and not just them, but really the taxpayers, because the taxpayers are the ones that are getting stuck here. Now, I don't know a lot about the status of Rev Group or Pierce in terms of their corporate organization. So I'm going to talk about something that may or may not have anything to do with what they're doing. But I do know that private equity and venture capitalists will come in and buy up corporations, small mom and pop corporations. They do everything they can to make them look profitable, and then they go and sell shares or maybe they sell the whole business out to other private equities. But the idea is to make it look good, okay? Make it look profitable for investors and for others to come in and invest. And when you have, basically you can say, we have $4 billion worth of contracts, that increases your profitability. And could that be why they're doing it? Like, why would you have a 4-year backlog? Well, you can blame a lot of things, but when you're trying to sell the company or sell shares or get investors in, and you can say, we've got $4 billion worth, it's over the next 4 years, we've got $4 billion worth of contracts to fulfill. That is, I think it's going to help you. Now, this may not be an issue if they're not headed in that direction, but it raises questions in my mind. Another thing, when I first heard of Rev Group, because I have an RV and they make Rev Group is bigger than just fire trucks. They recreational vehicles, and I thought Rev was engine revolutions, revolutions per minute, RPMs, and all that. And that's what I assumed. I hadn't thought about it, but you just used the term revenue, and I said, "Oh my God, Rev Group, revenue group."
Could be. Who knows, right?
And
Right.
I'm like, it's a double entendre.
I think it's recreational something vehicles, isn't it?
Yeah,
REV.
I don't know, but when I saw then when you use the term revenue, increased
Yeah,
revenues, I'm like, oh my God, is that what Rev Group means?
maybe it
So
is.
I don't know. I don't, but I know that municipal my own fire department, we can't afford a fire truck now. We had budgeted for maybe something in the five, six, $700,000 range. The truck we want is like 1.2 million, and we bought one in 2018 for 475,000.
Yeah.
475,000. We got a pumper, not a wonderful, bells and whistles, but I mean, it was a respectable Class A pumper, good size pump, good size tank, and everything. And 475, 1.2 million now.
Yeah, and
That's
that
from
was the example they
from
used. The senator
2018.
used. Right.
Yeah.
The senator said he bought one for 550 a couple of
Yes.
years ago, and
Yes.
it's now one
Yeah.
1.1.
Yeah. I mean, it's just insane. And certainly things have gone up. Coffee hasn't gone up, bananas haven't gone up, potatoes haven't gone up. What is going on? They've gone up, but not,
Not like
with
this.
inflation, not like this. There's something nefarious, at least is alleged, and certainly we've got that antitrust lawsuit out of La Crosse, Wisconsin, that we talked about.
Yep.
And so we'll see. We'll see where it goes, but it certainly is concerning, you know.
Yeah, and the DOJ is asking the right questions. I had been hoping that states attorney generals would get involved, but
Yeah.
DOJ is,
Well,
just as
I
good.
think if it keeps going in this direction, you're going to see that.
Yeah. Yeah.
You're going to see that, and I think it's ill-advised what they're doing. Maybe they had a certain model for their corporation and what they were going to do with investors and all that, but they need to change directions and change pretty quickly.
And then, I'll close with this, but the question really is, but then why are all the other manufacturers just as high? And I say this for both. Are you just following suit?
Mhm.
Or, right, are they buying in the same backlog? Because again, there are other manufacturers have exact same ridiculous prices and backlogging.
Yeah, I
Are they
guess
all
I'm
following the
not
same
I'm not
model?
familiar with the other manufacturers because and again I don't know all of them, but I know Rev Group. A lot of the ones that we think
A lot of
of
them.
have been purchased by. They were small mom and pop. Like when I
Sure.
started, these were mom and pop types or sort of family generational types of corporations, and they've been bought out by these by the folks
Yeah.
on Wall Street, and
Now, I can tell you, I probably do review an apparatus purchase contract once a week
mhm.
for the, and from all sorts of, and I'm doing the bonding and the financing for almost all of them. And I'm seeing the same thing. So it may be to come to Pierce's and Rev Group's defense for a little bit.
Yep.
Did everyone just follow suit, or is this truly affecting the industry?
Mhm.
I don't know. And
Well,
they're certainly not
there is
conspiring
one
with the
more thing.
others.
I think we talked about it before, and Trump is reported to be considering rolling back some of the diesel emissions requirements.
Right.
And if that happens, that has contributed in the mix of
Yes.
that has contributed tremendously
Yes.
to increase in the cost. And I think what we were looking at buying a truck just before the emissions went in, the latest emissions went in, and it was going to be about a $60,000 cost just based on the new emissions requirements. So
Sure. Sure.
that certainly is another factor that led to across the board increases. And if those get rolled back now, hopefully then there'd be a decrease as well. So
All right, let's do two or three discrimination cases. I'll kind of put them all together, skip around a little bit, but we'll do three of them together because they all are very similar in sense. But the first one is just a lawsuit, not a decision. And we're going to Ohio, where we're in Toledo. We have a fire captain who's alleging racial and gender discrimination, as well as being harassed and retaliated against. He just filed the suit. And
That's a female. It's a female.
she just filed suit, right? And she names the city of Toledo, 3 chiefs, a captain, 4 lieutenants, and a firefighter, which, by the way, is a very good tactic to name all those people as defendants individually, whether they have liability or not. It's a good plaintiff's tactic because it look how many people are involved. It gives a I don't know, good appearance to the lawsuit. In any event, she complains that she's been subjected to discriminatory treatment, harassment, intimidation, repeated internal investigations. For example, in 24, she was charged with policy violations related to vehicle backing procedures, but she wasn't interviewed, she claims, while similarly situated white captains, who don't know whether they're male or female, but at least they're white, and they said they got investigations before being disciplined. Okay. An investigation may or may not be required in their area, in their CBA or whatever, or maybe. Then she said a lieutenant allegedly filed multiple internal complaints against her, confronted her aggressively on it, and allegedly spread disparaging remarks, including investigations of reverse discrimination, right? That a black individual was discriminating against a white individual, presumably. She then also claims that an assistant chief who pursued investigations into her conduct, including falsifying reports, mishandling equipment, and she claims these were excessive and later leaked to the press, such that perhaps to try to ruin her reputation or whatever. She, second to last, claims that a chief and a firefighter allegedly made disparaging posts on Facebook about her. That should be easy to prove. I'm presuming, I don't know if they were part of the complaint as exhibits, but, and then she said there are other allegations of harassments, threats by the lieutenants, some social media posts, some extremist imagery, and threats of mailing items to her home that put her family at risk. These are pretty extensive, but yet a lot of it's easy to prove. If they're really copies of Facebook posts, chiefs should not be disparaging people if this is what happened on social media. It's not going to look good. So she may or may not have strong complaints. My lesson on this is, if what she says is true, wow, there must be some pretty damning evidence. And you would think that would settle quickly if what she says is provable and true. In any event, I want to skip over the Kirk one for the moment. I want to go to the federal magistrate has recommended the dismissal of a North Carolina firefighter's wrongful termination suit. And I'm kind of tying these 3 things together because they do have a common theme. But this is a recommendation. No one ever understands what a federal magistrate is. They're not like a law clerk. They're like a judge, but they write a decision. And usually, but not always, the federal judges read it and agree with it, but not always. Sometimes they, view things differently and change it. In any event, but here we have a recommended ruling, again, which is usually adopted. And this individual, Patterson, claims that there's been workplace disputes involving a Captain Moore and complaints that he made against a chief. And he alleged that after participating in internal complaints about Captain Moore and the chief, he was denied a promotion, suspended, subject to investigation, and terminated. But here's the thing. There were so many procedural problems with this lawsuit, it's recommended to be dismissed. For one, under the age discrimination, which if you're 40 and over and you're discriminated based on your age, I suppose you could, file for that. But he said that... And this is a little laughable. I hate to say this, but he says he was discriminated based on his age. The employer came forward on the McDonnell-Douglas test saying, well, you had an extramarital affair or a marital affair with a married woman, which led to many investigations, allegations of harassment, and community disputes. This is a point. If you are faced with something like that, maybe you don't want to file some of these suits, because it serves as a pretty good cause when the municipality comes back and says, we have a independent reason we took negative action against you, and here's one of them. And it's, since it was all over the community, I believe, or out in the community, made sense. So that was their defense. He made a hostile work environment claim, and that procedurally he didn't file in time. There's a 180-day requirement to file, and he missed that. So that's out. A retaliation claim was dismissed. And this is something you're going to see in the next ones, and this happens a lot. Said the time gap between these two complaints, that when I did something that you're retaliating against me, and then you retaliated against me, right, are too far. So normally, if you go out more than 6 months, so 6 months ago or a year ago, I did this to you, and a year later, you're taking this action and retaliation for that. The courts give you a very short time frame. 6 months is the longest I'm used to, but you see people going back a year, year and a half, 2 years,
Well,
and
there's a factual question. This gets washed out. We don't talk about it enough. There's a factual question here that you could go back 10 years and have a retaliation claim. The challenge is you've got to prove that the retaliation was due to some sort of protected activity. And how do you go about proving it? Well, one way is the closeness in time, the proximity in time. But there's other ways. There could be emails, there could be recorded statements, there could be witnesses who
yep,
overheard saying, I'm going to get Pinsky, I'm going to get Varone.
yep.
Those types of evidentiary things can allow a retaliation to go beyond that. But when you're trying to get that inference that it's due to something that I did, you're right, that's 6 months. And some places even 3 months. I've seen some courts really saying 3 months, but 3 to 6 months is about it. But you can't let it go on and on and on and then try to say, well, I said this 3 years ago and now you're retaliating against me. Unless you can prove it. If you can prove it a different way, that's a different story.
And look, people do stupid things. People will post online, I'm going to get you, or,
Well,
just you wait, that type of thing. So, not here, but in any event, so they get rid of the retaliation claim for that. And that's pretty common. You see that time gap be a big issue. And then there was a wrongful discharge claim, which fell under state law. There was a breach of contract claim. And they said, well, you're at will. There can't really be a breach of contract because you're at will. And then they went further with another one, which I thought this was really interesting. There was a tortious interference with a contract. I would have thought they'd said there can't be a contract, you're at will. So how can you interfere? That would have been the easy way for the court to say, I just said it, so there you go, you're out. But what the court does is they say, no, no, the defendants were non-outsiders to the employment relationship, meaning they're insiders or part of the employer. So the employer can interfere with his own contract. You can't sue the employer for interfering with a contract between you and your employee. So I thought that was very interesting. I've never seen a holding like that because I've never seen anyone try to sue their employer and allege you're interfering with your own contract.
yeah. Well, even like you have a representative, like you have, let's say you have a chief and you have a contract with your employer, which is the city or the fire department, and
Yep.
now that you're going to allege the chief is interfering with that contract, that would be an issue in every discipline, right?
Right,
So,
right. So to sue them for that, yeah. But I thought it was interesting. I didn't think this was all great lawyering. They should have known the procedural. They should have known the dates. They should have known the at will. They should have, right? It seems like, okay, we're going to try to throw something at you in the hopes for a settlement. Maybe that was the theory. I have no idea. But all of these to me seem pretty weak, and the judge picked right up on it. Okay, not lastly by any means. We have 6 or 7 stories today, so we have 2 more to go through, but this one ties together. And oh, this is mine, by the way. This is my lawsuit. So this is in the New York State Division of Human Rights. And this is an agency of New York State, but it is, I want to explain why this and other similar state agencies are very dangerous. So there's no rules of evidence in this quote unquote court. The judge is employed by the same agency, by the Division of Human Rights. And, you get a lawyer either for the Division of Human Rights or your own party's private lawyer. In this case, it was their private lawyer. But the biggest thing is they can award damages, like up to $1 million plus. And this suit, they sought over $1 million for what we're going to talk about. So as I'm trying this, I'm nervous, right? I'm always nervous. Whether I'm right or wrong, it doesn't matter. We won, but doesn't mean I'm not nervous for my client that they could lose $1 million. And these are non-insurable claims. But here's what happened, kind of. So this female, Eleanor Smith, was allegedly the first woman interior firefighter. She was a longtime president. She does not like some other people. A lot of people don't like her. So they brought her up on charges because she interfered with an investigation. She kind of put her nose in where it didn't belong, so to speak, and she interfered with an investigation that was going on independently within this department. And Patterson Fire Department, totally volunteer agency. So they bring her up on charges of interfering with investigation. And they only had recommended suspension and some anger management training. So it came to the membership, and the membership voted that penalty down, and people started standing up and saying she's a bully. They then kick her out for being a bully. And those allegations have gone on, but they kick her out. She turns around and sues, saying gender discrimination, etc. And I go back to, this is just my opinion as the attorney, but I go back to something you talk about with toxic people, and they're never going to recognize they're at fault, that they've done anything wrong, right? So this is that type of person, in my opinion. So, for example, and this is first, let me talk about a legal issue. The judge says we raise the statute of limitations issue. In New York and many other states, COVID stopped the statute of limitations from running. So you have to do these very complicated calculations. And if Zach, my old associate's listening, now he's in the PA's office and DA's office in PA, but he did the calculations notably well. And we raised them and said, listen, even though there's like a 180-day or whatever statute of limitations, COVID stopped it, but then it starts again, and they blew it for most of their claims. So most of their claims were kicked out for that. And we haven't seen a lot of those COVID statute of limitations. This is one of them, but it's a big deal because they're all coming to light now that you missed them during COVID. You missed the statute of limitations during COVID. You filed too late. In any event, but then I go back to your toxic type mentality you talk about, because she sends this rude email to the chief and says, well, I want to be off the ambulance list, and I'm not doing this, and I'm not doing that. And so she sues because she's off the list and won't get put back on. And the chief's like, well, A, you insulted me. B, you demand to be taken off, and I don't have to put you on. And, it's because you're anti-woman. I'm like, no, it's because you were obnoxious. Being obnoxious is not a protected class. Right. So, and then she says, well, I'm not on all the committees I wanted to be on, and that's because I'm a female. And well, and the judge agreed. She was in charge of the bylaw committee. She was the chairwoman of the bylaw committee, arguably the most important committee in the fire department. She was the chair of that, even though the bylaws didn't get done for many, many, many years. The judge says, come on, there was a non-discriminatory reason for that. And she, there are other things that happened, and she wanted to be reinstated to things. And she, they said, oh, you can't be treasurer. And they go on, but they had reasons for everything. So here's, right, our point to everybody. If you have a valid, independent, non-racially, gender discriminatory motive for doing something, you do it. But it's not going to stop people from suing. Right? They still see themselves as a victim no matter what, in my impression. Here we won. They dismissed all the charges, not only statute of limitations, but saying there was an independent, non-discriminatory reason for the actions they took. And I think that's important. People should stand on that if you really have one. If you have a fake reason for taking action that truly is trying to cover up discrimination, that's a different thing. The last one, though, I do want to say was kind of funny. She said, well, and this was bad lawyering to the lawyer who tried this to me. He comes up and says, look, we're not in the annual book. You took my client out of it. And look at this picture. You put a black dot over her picture. And he produces that. And I was like, okay, client, what happened? And so he submits one page of the book. We go through and, okay, well, the book's a couple hundred pages. There's like 13 or 9 other pictures of her there. And then, again, kudos to Zach. It was the funniest part of the trial. The picture they blacked her out on was with Hillary Clinton. And so the department's sitting with Hillary Clinton, and she didn't want to be in that picture for some reason, right? So they put a black dot over her face, because posing with the first woman, presidential candidate is a big deal. And so my question to her was, so tell me, Mrs. Smith, what was it about this picture posing with the first female candidate for president that you didn't want to be a part of, right? Why did you not want that picture in? And I just think that was I don't know, it gave a point. Like, why would you not want to be in the picture? Oh, you lost your
Sorry, my dog was barking and I just muted myself. But so she had she's alleging, at least in one of the proceedings, she's alleging that an act of an adverse employment action was taking her picture or blocking her picture out. But then it turns out she asked the department to
yes. Yep, and she admitted that under cross-examination. She admitted it, and this whole lawsuit, which I mean, this trial went on for I don't know 7 8 months, not every day, obviously, but we kept going back and forth and back and forth, and cost a lot of money, all over things that there was a valid reason for, and but was just somebody, in my impression, my opinion, who can never take fault. I mean, she sent a letter to the chief saying, "I have no faith in your leadership," and so the chief didn't put her back on certain things. Well, okay, that's not because you're a woman. That's because you,
What did you think was going to happen when you did that? You think somebody's going to say, "Oh, okay,"
right.
or
But this is what most lawsuits are built on. This is the normal lawsuit. So anyway, but we won. I would
so
say
now
that
does she now what's the next? Because this was an administrative procedure, right? So
yeah.
now does she now have an opportunity to go to court, take this to court,
No,
or
no,
is
it's
it?
either or. It's either
Is oh
or. I
oh
will say what would have been more interesting, though I'm glad I won. Had we lost, I would have taken this under the Seventh Amendment case. That
oh
I think, to me, look, the federal EEOC, you get a jury trial,
right
right? You get a jury trial for the federal, same thing. And this had a federal companion case. It's just the federal government says to the state, okay, fine, you handle it. And
mhm,
the complainant can choose their choice of forum. They can go to the federal government, they can go to state government here, or they can
mhm.
go to a jury. Why would you ever go to court? Right? Why would you ever go to court? Because you have a jury, you have rules of evidence, right? Here, they have no rules of evidence. They have right, again, a judge employed by the same agency, and they can get the same money.
Wow,
So I think you have to have a Seventh Amendment right to a jury trial. And
yeah,
while we're on that, Kurt, you may not know this. Kudos to Chip Comstock.
I did see that. Go ahead, let him.
Yeah, big
Yeah,
news. So let's give a shout out to hopefully future Judge Chip Comstock. But
yeah.
he used my Seventh Amendment case in right saying that there's, for everyone who hasn't seen it, for that the federal Constitution, which guarantees a jury trial in civil matters. All right, if you're in front of like non-criminal civil matters, where we got in New York a permanent injunction against the state of New York from prosecuting certain paramedic and EMT until they give them a jury trial. And Chip has that same issue with a paramedic or something like that. And the state denied him a jury trial. He teed it up for them. And he went to a judge using our papers and saying this is coming to the Supreme Court to consider whether the Seventh Amendment issue should go to the court. So the Supreme Court, somewhere between October 3rd and 8th, will have an answer whether they're going to consider whether the Seventh Amendment applies to the states. Anyway, he got a temporary restraining order against the state in Ohio, I guess, from prosecuting paramedic or EMT. So that's a big deal. This is spreading, but ultimately, and that's where I would have gone with this. That's where I would have gone with this Division of Human Rights charge, because you shouldn't have a choice of forum where one choice involves a jury and one does not. That makes no sense to me.
Mhm.
So, okay, so enough on that, and let's end. I have this issue now multiple times in my own practice. But here's what we got. Now we have yet another one, right? And there are so many. I probably have 3 or 4 of these in my own practice now, at least. So we have a Cleveland fire chief who's been placed on leave after he, I guess allegedly, posted a cartoon on Charlie Kirk's death. And what he said is what's important, right? And so let's focus our First Amendment. I wanted to end on this because I thought it's really deserving of some of our time. Hence the reason you posted it. He shared a cartoon. The chief shared a cartoon video on his personal account. Now, that part, maybe you have to clarify. I'm not sure what he meant share. Did he just literally share it? He didn't write it, but he shared it, right? Put it
I
forward.
think that's my understanding. Yeah.
Yeah, I would think so. And there's a video which depicted a machine gun on a pedestal surrounded by kneeling elephants, which I presume are Republicans. And in the clip, one elephant declares, "Bring out the next sacrifice," while a quotation attributed to Charlie Kirk scrolls across the screen. It was online for a while and then was deleted in mid September. So the mayor, getting probably some good counsel, says that while there are First Amendment rights, right, they're not unlimited. And he says, where they impact the ability of the community to trust the fire department, et cetera, right? So he must have got some good counsel because he recognizes, as we did on the last show, there's limitations to the First Amendment. I think this post probably does go a lot too far.
Yeah, and I think this raises something that we talk about in my social media classes quite a bit, and it goes back to our Pickering balancing test. But the first thing is got to be a matter of public concern, and number two, got to be as a private citizen. Now, we can look unless somebody dresses up their social media account. You're going to pretty much be a private citizen. And there's a few firefighters out there that have extensive social media websites and social media, you know, home pages that it looks almost like the fire departments, like they're holding themselves out as a spokesperson. But most firefighters, that's not going to be an issue. You get by those, then we're into the balancing part of it. What happens when you're the fire chief, though? And, a fire chief does not have to announce to people that I'm the fire chief.
Right.
Okay. Especially in a metro city, the fire chief is recognized just by either their name or their face. And it's like the mayor, it's like the governor, it's like the president, that you don't have to say I'm the president. People recognize you. And so there's a factual question about just how much a fire chief can actually be a private citizen, can say something as a private citizen. That is what struck me in this one, which sort of complicates the ability of people who are in that high-ranking position to actually take advantage of the First Amendment. Now, maybe if it had, I don't know, there may be some circumstances where maybe they can, but I just think that it's very difficult for a fire chief not to be viewed as a spokesperson for the fire department because,
and it's probably on their Facebook page saying, I am the chief of the fire department. A lot of people have their bios on there.
right.
In case, because somebody asked me this a while ago, in case people think that sharing and liking are not speech, the courts have resolved that. It is absolutely speech. If you click like, if you share something, right, unless you put something like hypothetically, if the chief put this type of post is offensive,
Right.
right?
And we will not tolerate this. That's important context too, because when people can share something and because they're offended by it,
Yes.
people can share something because they like it. So there's a little bit of ambiguity in there, and that is the sort of wiggle room maybe you have in a disciplinary hearing to argue. But I don't know. This particular situation doesn't seem like he was posting it because he was offended by it.
Doesn't appear that way. So the mayor's comment that it romanticizes gun violence, I think that post does. We went back and forth last week with 5 or so examples. I had one, I can't talk about it, but one that just came up last week as well. And, they're so close. Some of these comments are so close. Like, I don't feel sorry for him. I don't regret his death, right? Or couldn't happen to a nicer guy. They're not talking about that he was murdered necessarily, they're endorsing murder. They're saying they couldn't stand the guy. So change it, right? If somebody got on and said, Adolf Hitler has been killed, great, we're great, we got him. Would anyone say anything that it was negative, that romanticizes gun violence? No, they're talking about the end to a person who gives speech they don't like. But something like this, when the post is in itself depicting violence, I think that's why I say the line has been crossed.
Yeah. Again, I'll go back to my metaphor of a close play at second base, and you have to be there, maybe slow it down, do the instant replay thing, look at it, and you got to look at all the factors that go into it, and then you make the call based on that. But otherwise we're left trying to it looks like the guys who have even numbers on their jerseys are always safe, and the guys who have odd numbers on their jerseys are always out, and that's got nothing to do with it. It's really about all the nuances that get into that decision.
And I find the harder part, I guess my last comment on this, I find the harder part is it a question of laws or a question of fact? So the question of law, right, is whether that speech might be protected by the First Amendment, but the question of fact might be what did that speech mean?
Right.
And is that a jury? Is that a judge? And those are tough issues that come up in real trial practice. And you spend a lot of time saying, Judge, I want you to decide versus the jury, because a jury, you don't know what you get for the views of a jury. A judge, you don't know either, but you know whether they're Republican or Democrat most times. And so you can gauge whether I want a certain judge. So, and this is the thing that non-litigators never see happening behind the scene, right? Do we want a jury? Do we not? Do we want this judge? Do we want to try to get the judge recused because he
Do we
made
want a
a
state
public
court
statement?
we want a state court jury, do we want a federal court jury? So
Yeah, I mean, so tough issues, but anyway, I don't know. I don't think that's protected by the First Amendment. My 2 cents.
yeah, I don't either. I think it could fail on the fact that the fire chief, it's very difficult for the fire chief not to be a spokesperson. And if you are a spokesperson, if you say something as a spokesperson, you do not have First Amendment. We don't even have to get into the balancing test.
Right. Low-hanging fruit.
It's not protected. It's not protected speech. So
I agree. And it sounds like the mayor's already got counsel on this. He knows darn well what he was doing on the First Amendment. So he's probably very much on solid ground.
yeah.
That's it for this week.
All right.